Western Pennsylvania has a very large elderly population, and with that comes very important legal needs and legal questions that govern the elderly. Frequently we receive calls and we receive questions from elderly clients and their loved ones relative to three very important questions. Question number one is always, in the event that I or my loved one needs long-term or nursing home care, who or what pays for such care? The second question that is always asked is, what happens to my hard-earned assets that I or my loved one have worked a lifetime to acquire in the event that they would require long-term nursing home care? And the third question that is always asked that we address is, what legally can be done to protect one's assets in the event that they require long-term or nursing home care? And essentially we attempt to answer all these questions, and really the answer to the first question is, and it surprises many people, that they, in the absence of a long-term care insurance policy, they and not anybody else will pay for their nursing home care. That is, that a nursing home will look to a person's own assets to pay for their nursing home or long-term care. If they do not have enough assets or sufficient assets to cover their long-term care needs, then the loved one may apply for a program known as medical assistance, and that's a program that's administered jointly by the federal and state government. The second question that always arises, of course, is what happens to the assets of my loved one in the event that he or she may require long-term or nursing home care? And as referenced earlier, in the absence of a long-term care insurance policy, that person's assets will be consumed or spent down by the facility in the event that they require long-term nursing home care. The third question, of course, then becomes, well, what legally can be done to the extent possible to protect one's assets in the event that I or my loved one require long-term or nursing home care? And typically we spend a lot of time with clients explaining that and going over some strategies that legally can be done to protect their assets in the event they do require long-term or nursing home care. With that, there are some very important misconceptions that are out there that we address with clients when we meet with them. The first misconception is that a loved one may say, well, if I put my child's name on any of my assets, will that protect a share of those assets? And the answer to that, unfortunately, is no, it will not. The second misconception that we frequently deal with is, if I transfer my house or any other property to my loved ones and just put in the deed that I transferred it to for $1, does that make it a bona fide sale, and therefore am I permitted to do that? And of course the answer to that is no. Essentially such a transfer is a gift. We explain to clients all of the circumstances and as well the consequences of taking such actions. We like to explain to clients in layman's terms what the law is in this area of the law and how best we can serve our elderly clients with the appropriate legal advice under these circumstances.